Nevada's lease termination laws have evolved significantly in recent years, as the state has grappled with rapid population growth and a tight rental market. If you own rental property in Nevada, the rules are more detailed than you might expect, and the consequences for getting them wrong can be costly. The governing law is found in Nevada Revised Statutes, Chapter 118A, the Residential Landlord and Tenant Act, along with the state's summary eviction procedures in NRS Chapter 40. Let's start with no-cause termination. For month-to-month tenancies, Nevada requires the landlord to provide at least 30 days written notice before the termination date. The notice must specify the date the tenant must vacate and should be delivered by one of the methods authorized by the statute: personal delivery, leaving a copy with a person of suitable age at the tenant's residence, or sending by certified or registered mail. However, and this is critical, some Nevada jurisdictions have enacted additional restrictions on no-cause terminations. The City of Las Vegas, North Las Vegas, Henderson, and Reno have all been active in tenant protection legislation. Landlords need to check whether any local ordinances impose just cause requirements or longer notice periods beyond what state law requires. Nevada's rental market has been the subject of intense political attention, and local rules can change quickly. For fixed-term leases, the lease expires at the end of the agreed term without additional notice required, unless the lease specifies otherwise. If the tenant stays beyond the term and the landlord accepts rent, the tenancy converts to a month-to-month arrangement, subject to the 30-day notice requirement. For week-to-week tenancies, Nevada requires 7 days' notice from either party. Now let's cover termination for cause. For non-payment of rent, Nevada requires the landlord to serve a 7-day notice to pay or quit. Under NRS 40.253, the landlord must provide written notice giving the tenant 7 judicial days, meaning weekends and holidays don't count, to pay the full amount of rent owed. If the tenant pays within the 7-day window, the notice is void and the tenancy continues. If the tenant doesn't pay, the landlord can file for summary eviction. That distinction between calendar days and judicial days is extremely important in Nevada. 7 judicial days can easily stretch to 9 or 10 calendar days when weekends and holidays are factored in. Landlords who miscalculate the timeline and file too early will have their cases dismissed. Here's another important detail about Nevada's non-payment process. The state recently strengthened requirements around what information the notice must contain. The notice must clearly state the amount owed, must not include any charges beyond actual rent due, and must provide the tenant with information about how to contest the notice. Failure to include this required information can invalidate the notice. For lease violations other than non-payment, Nevada uses a 5-day notice to cure or quit for most violations. Under NRS 40.2516, the landlord must provide written notice specifying the violation and giving the tenant 5 days to correct it. If the tenant cures within 5 days, the notice is void. If the tenant doesn't cure, the landlord can proceed with filing for eviction. For certain violations that are not curable, or for situations where the tenant has committed the same violation multiple times, Nevada allows the landlord to serve a notice to quit without providing an opportunity to cure. The specific circumstances in which a no-cure notice is appropriate are defined by the statute and case law. For nuisance conduct, including excessive noise, threatening behavior, and activity that substantially disturbs other tenants, Nevada allows the landlord to issue a 3-day notice to quit. Under NRS 40.2514, if the tenant's conduct constitutes a nuisance, the landlord can serve a 3-day notice, and if the tenant doesn't vacate within 3 days, the landlord can file for summary eviction. This expedited timeline reflects the seriousness with which Nevada law treats conduct that affects other residents. For criminal activity, Nevada provides even faster action. If a tenant is involved in drug-related criminal activity, unlawful discharge of a weapon, or conduct that poses an immediate threat to health or safety, The landlord can serve a 3-day unconditional notice to quit, meaning the tenant must leave within 3 days with no opportunity to cure. This is the fastest termination pathway in Nevada and is reserved for the most serious situations. Nevada also has a specific provision for situations involving illegal drug manufacturing. If there is evidence that a controlled substance has been manufactured or distributed on the premises, the landlord can pursue immediate eviction, and the court can schedule an emergency hearing. The eviction process in Nevada uses a summary eviction procedure that's designed to be faster than a traditional lawsuit. After the notice period expires, the landlord files an affidavit and order for summary eviction with the Justice Court. The tenant then has the opportunity to file an affidavit opposing the eviction, typically within the time frame specified in the court's order. If the tenant doesn't file an opposition, the court can enter a default order for eviction. If the tenant does oppose, the court schedules a hearing. Nevada's summary eviction process is generally efficient. Uncontested cases can move from filing to judgment within 1 to 2 weeks. Contested cases require a hearing and may take 3 to 5 weeks. Once the court issues an order for removal, the constable carries out the eviction, typically within 24 to 48 hours of receiving the order. This makes the post-judgment phase of Nevada's process notably fast. One thing that's unique about Nevada's eviction process is the role of the constable. In Clark County, which includes Las Vegas, the constable's office handles eviction lockouts and is generally very efficient. Landlords in the Las Vegas area can typically expect the physical removal to happen quickly once the court order is issued. On the tenant side, Nevada provides several grounds for early termination. If the landlord fails to maintain the property in habitable condition, as we covered in our Nevada habitability video, the tenant can provide written notice and allow the landlord the required time to make repairs. For essential services failures, the landlord has 48 hours. For other habitability issues, the landlord has 14 days. If the landlord doesn't act, the tenant can terminate. Tenants who are victims of domestic violence, harassment, sexual assault, or stalking can terminate the lease early under NRS 118A 345. The tenant must provide written notice along with documentation such as a valid temporary or extended protection order. The notice must be provided at least 30 days before the intended termination date. The landlord cannot charge early termination fees, and the tenant's liability is limited to rent through the termination date. Nevada also requires the landlord to change the locks at the victim's request if the perpetrator is not a co-tenant. Active duty military members are covered by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Nevada has a significant military presence, including Nellis Air Force Base and the Nevada Test and Training Range, making this provision relevant to a meaningful number of tenants. Nevada also provides early termination rights for tenants who are 60 years of age or older and whose income has decreased or whose physical or mental ability has changed, such that they need to relocate. The tenant must provide 30 days' notice along with documentation from a qualified professional. Nevada strictly prohibits self-help evictions. Under NRS 118A.390, landlords cannot change locks, shut off utilities, remove doors or windows, remove the tenant's belongings, or take any action to force a tenant out. The penalties are among the harshest in the country. The tenant can recover actual damages or up to $2,500, whichever is greater, plus attorney's fees. In cases of willful violation, the court can award treble damages. These severe penalties make self-help eviction extremely risky in Nevada. Nevada also has strong anti-retaliation protections. Under NRS 118A.510, landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant exercising any right under the Landlord-Tenant Act. The protection lasts for a specified period after the tenant's protected activity, and any adverse action during that window creates a presumption of retaliation. One practical consideration for Nevada landlords: The state's rental market is heavily concentrated in the Las Vegas metro area, which includes Las Vegas, Henderson, North Las Vegas, and surrounding Clark County communities. The justice courts in Clark County handle an enormous volume of eviction cases, and while the summary eviction process is designed to be efficient, the sheer volume can sometimes create delays. Landlords should file promptly and ensure all paperwork is complete and accurate to avoid additional delays caused by deficiencies in the filing. Nevada requires landlords to return the security deposit within 30 days of the tenant vacating the property. The landlord must provide an itemized accounting of any deductions. If the landlord fails to return the deposit within 30 days, they may forfeit the right to retain any portion and could be liable for the full amount of the deposit. Nevada does not allow landlords to charge non-refundable deposits. Any deposit that is intended to cover damages must be refundable, and the only amounts that can be designated as non-refundable are specific fees like cleaning fees, which must be clearly labeled as such in the lease. For the complete guide to Nevada lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.